this is chapter 5, and it's the second part. And so we'll be done with chapter 5 at the end of this, and then we will have chapter 6, which is a summation, and then any final video after that would be only covering the appendices, and that's just if, I think the stories would be good, so we'll see. All right, so here we go. We start off with inquisitional torture versus due process. So common law has never included torture. And so men have introduced torture into common law countries, but it has never lasted. The common law's engine of truth is cross-examination of a witness under oath, limited by the right to remain silent. The civil law method of extracting truth is through the confessional, using fear of torture or torture. And in our culture, you see that in so many movies. So inquisitors' goal is confession. So that was one of the things that we saw in the Bible when it came to Pilate to question. You would see them scourge Jesus and question him. And it was easier for them to question one man because Pilate already knew that the Sanhedrin were not good men and, just trying to fulfill their own will. And then the crowd, full of hatred, some of them probably couldn't even, put to words why they were upset. They were just, jumping on the bandwagon. So the civil law allows inquisition. Inquisition depends upon secrecy, seduction, and intimidation, and enabling the state to become lord over the conscience of defenseless persons through police interrogations, fear, physical torture, or discomfort, and emotional distraughtness, followed by promises of relief if the person just confesses to what the inquisitor wants. Promises that are usually not kept. Inquisitors are abhorred to the common law tradition. False systems of law claim authority for inquisitions. The common law protects freedom of conscience by due process through two means: the right to remain silent and the right of the confessor to muzzle the priest to whom he has confided in confession using the priest penitent privilege. Presumption of innocence. In common law, the accused in a criminal case is innocent in the eyes of the law until proven guilty beyond a reasonable doubt. The law will not torture the one it presumes innocent. In civil law, the accused is presumed guilty. The accused is required to prove his innocence. In common law countries, guilt requires certainty beyond any reasonable doubt. The reasonable doubt standard has two parts. First, does the jury have a doubt about the accused being guilty? Second, if so, is that doubt reasonable? If that doubt is reasonable, then the verdict must be innocent because the doubt must be beyond reasonableness. What qualifies as reasonable? The government cannot take life, property, or liberty from the accused innocent until proven guilty, unless the answer is absolutely clear without a doubt based on reasonable facts. The reasonable doubt standard for criminal cases is the common law standard and has been since America's inception. If the juror believes the accused is likely guilty but retains a doubt that is reasonable in light of the facts as they understand them, the law demands that the juror insist upon an innocent verdict. Civil law doctrines rest upon fundamental false notions of government, authority, and power. The civil law only needs one or a few powerful political figures to implement its power, offering total government and promising security, peace, and safety without personal discipline. It is utopian and appeals to frail humanity to quell fear. So first, civil law only requires a few books of laws. That is their code. Second, civil law does not demand an organized electorate, but only a few powerful personalities. Third, natural man leans toward civil law because he is estranged from God and often has utopian fantasies. Fourth, the world perceives Roman civil law as Christian because the eastern and western branches of the Roman imperial church use civil law in the form of canon law. Fifth, the civil law tradition has always been and remains the product of universities, legal scholars, and abstract reasoning, giving it an air of intellectual dignity, prestige, and superiority. Because Satan knows how to market, right? He knows how to infiltrate. He knows how to take a good group and infiltrate it with the filthy despicable, and then he markets it through the universities. No, awful. So civil law tends toward concentrated power, demanding quick response to the orders of central command, requiring the individual surrender his rights. James Madison, author of the U.S. Constitution, said, "The accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, few, or many, and whether hereditary, self-appointed, or elective, may be justly pronounced the definition of tyranny." So just a few people shouldn't have all the power, is what he's saying. Contrast this statement with the following statements. Adolf Hitler said, "The state dominates the nation because it alone represents it. The state is the substance whereof individuals are but accidents." Joseph Mussolini said, "Everything for the state, nothing outside the state, nothing against the state." And I think it's Fitch said, "The state is the superior power, ultimate, beyond appeal, absolutely independent." So again, all idolatry, all of it. The following statements can be made about the state. The state is attributed the attributes of deity, recognizing no authority about itself. The state's command is law, and there is no appeal. All judges, magistrates, government officials, and employees are servants of the state. Law does not bind the state or any employee of the state. So they're above it. Revolt or coup is the only way to get rid of undesirable rulers. Daniel's Roman Empire, civil law among men. Look at Daniel 2:7 and then David 7:28. Records Daniel's recounting of Nebuchadnezzar's forgotten dream and Daniel's interpretation of it. So if you're familiar with this story of the Bible, the dream included 10 toes of iron and clay. This is believed to be the power and law of Rome mixed with clay, which is humanity. So Rome is the iron, humanity is the clay, and they don't adhere or bond together. So iron and clay are incompatible in essence. Rome's referred to her legions as iron, and potter's clay indicates humanity in its weakness. See Romans 9:21. Lord Mansfield said, "The law does not consist in particular cases, but in general principles, which run through the cases and govern the decisions of them. The first principles are personal, relational matters, your relationship with God, and his perfect divine, inerrant, and universal pattern of law and government found in the Bible." So in general, each individual receives authority direct from God through natural means and will answer direct to God. Law has always been in the mind of God. It is not created by men. Government officers and employees are under the same law as the people. Public judges, officers, and magistrates are responsible to God and to the people. Common law demands judges to be independent from the king. Executives and magistrates or judges can be impeached and removed. Everyone is entitled to due process. The right to trial by jury is a foremost defining quality of the common law. The scriptures have preserved and undergirded and upheld the common law. Common law's distinguishing precepts are habits of mind and written customs articulated in the courts and applied to law. First, common law requires lower courts to follow higher appellate court findings. Second, common law is inarticulate until a court expresses its judgment. Third, the judge or the juror decides a given case with the presumption that the law's proper application already exists and he must discover or discern it. Fourth, ratio decidendi are the reasons given by the appellate courts for their rulings and establish the common law. The principles of the law never change, but the persons and circumstances subject to the principles change and require fresh application. There are 5 facets of common law: property, contract, agency, trust, and tort. So we're going to go a little bit more into those, section 533. Okay, so to understand these 5 legal relationships brings an understanding of their interdependency. It is to know the common law. So this is on page 702. To avoid legal misdiagnosis, says Rounds, counsel needs to know the common law, not know about the common law. To become familiar with these relationships is to lay the foundation of understanding for knowing the first principles of the common law. The common law categories of law are best defined and understood by comparing them to demonstrate their likeness and contrasting them to reveal their differences. An agency relationship arises when one person, called the principal, gives authority to another person, an agent, to act on his behalf, requiring the agent to look out for the interest of his principal. A contractual relationship arises where parties each promise to provide reciprocal benefits while each looks out for his own interest. A tort arises where one person lawfully trespasses upon the rights of another, negligently or intentionally. Property is one's right in a thing to the exclusion of others. Whether that thing is tangible, such as the right to use and enjoy property such as land, or personal chattels, or intangibles, such as the right to speak, to act, to enjoy relationships, the right to association or to privacy, the right to not associate, disassociate, or reveal information. The trust relationship arises where a trustee holds title to property for the benefit of another. Each of these 5 relationships calls upon principles of the other 4, with the trust relationship being the most complex arrangement of these relationships. That does help. Let's pause. So the next chapter, I looked at it and it's kind of confusing and I don't like it because it talks about the Republic and Republican. And I don't think he has a clear comprehension of it the way Anna does. And it says common law versus Republican forms. This is on page 705. It just, when I read it, it doesn't seem like he has a clear comprehension. So what I did was I pulled up one of Anna's articles, Republic versus Republican states. So when you click on that, I believe that will probably give you a better comprehension than his very small portion on that. Because a Republican form of government is not the same as republic form of government. And that should be our first clue that the Federal Republic government is a different beastie than the government guaranteed to us under the constitutions. The state republics created to be members of the Federal Republic are a different government apart from and operating in different jurisdiction of law from the actual Republican states, guaranteed in the form of, in 200-year-old French. As we encounter another difference between English and Latin-derived languages. So if I would suggest going in and doing a search on her website, which is the annavonreitz.com, put in Republic versus Republican, and then read this article a few times until you start, wrapping your head around it. But this is going to give you a more clear comprehension than the section of the book. So I'm gonna go back now. Okay. So Judge Joseph Story said democracy has many striking points of resemblance with tyranny. The ethical character is the same, both exercise despotism and the decrees are in the one, ordinances and arrest are in the other. Where the will of the majority is the final power of law and government, the majority will wield tyranny against the minority. All right, so a good point the book makes on page 711 is no one has ever shown that the majority, by its character or its numbers, ensures justice. Moreover, it is false to think that opinions held by the greater number of people indicate even a probability that the opinion of the majority is right, and therefore the majority will has superior right over the minority. Scripture is clear. The wide gate and the broad lead to destruction, and many are the ones rushing headlong through it. The narrow gate and the narrow way lead into life, but few are the ones finding it. So we will be moving on to 5351. Majority power over the courts. Late 18th century French revolutionaries induced and then exploited the fear among the people that judges, unless stopped, will always meddle with the popular will of the people by overturning representative legislation and the referendum. This fear forced the French to adopt Rome's code, and it was the Code of Napoleon, enabling Bonaparte's tyranny through control of the courts. Americans have not feared judicial power, but have impeached or ran judges out of town that refused to follow the law. Rah, more of that. Jury veto of the majority will. Common law has developed a jury tradition whereby 12 individuals randomly drawn have authority to veto laws that have been passed by refusing to apply them in particular cases. The jury has the power to refuse application of the majority's legislature in particular cases if it believes that the application is unjust. Major differences between common law versus civil law. And I think this is just going to be a very short summation. And then he actually has a chapter where he just wraps things up. So that'll be the 6th chapter. So we're almost done with 5. Common law binds government officials and employees as well as the people. Judges rise from private practice. Judges are independent of the executive and legislative branches and equal in dignity with them. The courts publish minority judicial opinions with their majority opinions. Civil law does not bind the state, its officials, or employees, only the people. So remember, those civil servants are above it. That's why they didn't have to get their shots. They were mandated to. Judges come from civil service and remain in civil service. They are career government employees. Minority judicial opinions are not published. Common law trials are adversarial. The common lawyer owes absolute loyalty to his client and is independent of state control. Determination of facts is for the jury. Common law responds foremost to protect private relationships. Civil law trials are inquisitorial. Common law jury verdicts and written opinions are evidence of the law's discovery. Court opinions are specific applications to past events of relationships. Common law speaks in retrospect. The common lawyer seeks judgment of past cases on similar facts and asks what is the principle threading through these written opinions. Civil law's code speaks in prospect or future prospecting. It judges what it believes will happen, then attempts to force the facts of any given dispute into a provision of that code of laws. The civil lawyer and judge consult the code to know the will of the state. End of chapter 5. Woo.